Okay, Bisha.
All right. Well, good evening, everyone, and welcome. Welcome to HCDVCC Connects, the evening edition, where we are launching deliberate dialogues on the intersection of domestic violence and the criminal justice system. Barbie Brashear, our executive director, will give us an overview of the series of what it's about. However, at this time, I would like to introduce you to one of our panelists. We were going to have two panelists tonight, and however, as in life, as we've learned over the last 24 months, sometimes things happen and we have to do a different thing. And so one of our panelists, Jennifer Herring, will not be with us this evening. However, we do have Mario Garza, who is the president of the Professional Bondsman of Harris County. He is the owner and operator of First Advantage Bail Bonds in Houston and a former civil criminal paralegal with over 13 years experience in the legal field. And just in having the opportunity to talk with him for the last few minutes, he comes to this panel tonight with a wealth of experience and truly a heart for justice. So please help us welcome Mario Garza, and I'll turn it over to you now, Barbie.
Thank you, Bisha. Welcome, everyone. I want to just kind of set the stage for the why behind the Deliberate Dialogue series. Some of you are familiar with the HCDVCC Connects that Bisha does every Monday on Facebook Live. And we wanted to build on that idea as a group. As the Domestic Violence Coordinating Council, Amy, Alicia, Thisha, Rebecca, Nidia, a few of us have been talking about ways to just provide more information to not only ourselves, but to the public. And we all know that we are coming out of a couple of very intense years of pandemic and how that has impacted so many survivors and victims across our community as well as across the nation. It's also created this perfect storm of challenges for our systems, for law enforcement, for criminal justice in particular. We've seen such a challenge in our court systems, backlogs, delays from family, criminal court, across the spectrum. So, as we were kind of digging into some of these issues and reflecting on the work that we've done in the past, which included our community safety assessments, we really dedicated ourselves to, before we can implement change or even recommend anything for change, it's really important to know what's out there. What do we have? How's it working? Who are the systems players? So that's where this series is coming from. These deliberate dialogues are coming from that place. And we wanted to focus this year on the intersection of domestic violence cases. And when we say domestic violence, we're speaking directly to intimate partner violence cases and that intersection across the system of criminal justice. So you'll see over the next few months, we've been very deliberate, and Amy Smith has been so good about helping us name our topics. And our March convening, which is what we're here for tonight, is to think about what happens, what do cases look like pre-conviction. So that's where we're at tonight. We do want to spend a little bit of time kind of thinking about the role of pretrial. We had hoped to have some information around jail reentry project from the Harris County Sheriff's Office, and hopefully we can get that information to you in the future. And then lastly, and fortunately, Mario is here to kind of speak to us about bail and bonds and what that looks like. So hopefully this is an opportunity to learn. We will entertain questions in the chat. So as questions come up, if you want to put them in the chat, but we're just going to kind of launch in. And Amy, do you want to speak to pretrial just a little bit before we jump into bail and bond, because that might be a little more helpful and give us some context. Does that make sense?
Sure. Yeah. Welcome everyone. Thank you so much for being a part of this tonight. I'm going to touch a little bit on pretrial services, which is actually a county agency. They were going to join us, except that again something came up, and so we're doing the best we can. Just a little bit about pretrial services, which is an actual county agency. They get their budget from Commissioner's Court. However, they have a committee that's made up of judges from both felony and misdemeanor courts that kind of help and provide guidance for what they do and what their objectives are. According to their mission statement, they are to provide accurate and timely information to assist the judicial officers in Harris County with making informed pretrial release decisions and to monitor defendants released on bond, to promote compliance with court orders and court appearances, and to support public safety. So basically they have two primary functions. One of the first function is to investigate and compile a report that's given to a judge to determine a detention, whether or not a person stays in custody or whether or not they're released on bond. And also the other thing that they do is they monitor those folks that are released on a bond, on either a personal bond, which means that they did not have to put up any money to be out on bond, or if a judge orders them, then they will supervise they'll supervise that person while they're out on bond. The department structures all activities to assure that they are making their appearances in court and to minimize the danger to communities. In the last legislative session, Senate Bill 6 passed. And so one of the things that Senate Bill 6 did was in all pretrial decisions that they were now, in all pretrial decisions that they take into consideration the age of the suspect, the type of offense the suspect allegedly committed, if there are any pending charges, if there were any prior convictions, if there was any prior failure to appear at a court hearing, and if they had been previously sentenced to any type of incarceration. So info from the pretrial services and their report are used by the courts, the DA's office, defense attorneys, law enforcement, and other criminal justice agencies. And yes, the general public is taken into consideration when they are making some of these decisions. They do talk to the friends and family members of the defendant to collect the information, and they will also incorporate some information from the complaining witness. So that's kind of it in a nutshell. So Mario, I'm sure you can expound on a little bit, but again, that was my research from their website. So anyway, so thank you.
That was great, Amy. Thank you so much. So just to kind of build on that, Mario is with us, and Mario, you can just, I would ask you to just kind of introduce yourself to us, talk about you kind of have a dual role here tonight. You are a bail bondsman, but you also serve on the county board, and I believe you chair that board. Is that correct?
I just recently got elected to the Harris County Bail Bond Board. I'm not the chair.
Okay.
My predecessor who passed away, Glenn Strickland, he was the chair, but someone took that over, Angela Rodriguez, which is the JP judge. But yes, that's my background. To talk about domestic violence, to give you an idea, domestic violence cases in the past used to be $500 bonds. When the O'Donnell settlement, which was the federal settlement that allowed for misdemeanors to be released on PR GOB bonds, which are general order bonds, they made those bonds $100. What's interesting about that as well is that what you saw was a pattern of people who violated protective orders and were re-released on a PR bond or a GOB bond. And if they didn't get released on a GOB bond, the bond was extremely low. So we were dealing with both the federal lawsuit, which, mind you, was only supposed to release misdemeanor defendants. So in cases like impeding breath, which are felonies, they were being released on PR bonds as well, which O'Donnell was never supposed to extend into. It was only supposed to cover the misdemeanor cases. One thing that also changed was, you remember the call that the victims used to get, the automated call, when the person that assaulted them made bond, they got an automated call. For some reason, they did away with that, about 4 or 5 years ago, where they just stopped sending the victim a notification of any kind, which I never understood why that stopped. I mean, that's just basic common sense, like, hey, this guy bonded out about 5 or 6 hours, 8 hours, he's going to be out. So you should probably move or leave home or go stay with a relative or something like that. In the case of Caitlin Guajardo, who was murdered, she had no idea that her husband was out.
I think Mario just froze. Let's give him a second and see if he is able to come back.
Right.
There.
Well,
Okay.
he was actually hiding in the closet while she was in there moving, and she had relatives with her who left because they didn't see him. They thought she was okay. So that's an example. But the overall picture is that the impeding breath and those type of domestic violence cases, there should be at some point where they're disqualified from a PR bond, which, how many chances do you get is my concern.
Yeah, Mario, I think you're speaking to something that everyone here has some great concern for as well. And I really appreciate you helping us understand and sharing the context of the Ricardo case. I'm wondering if you can back up a little bit for us, and just for those of us who may not know what a bonds person does, share with us, what is the role of a bonds company, a bondsman, a bondswoman?
Yeah.
What does that mean? What is that for?
Absolutely. The way a bond works is a bond, meaning you're bonded to the court. Our main job is to ensure that the defendant appears for all their court dates. That is our job. That's why let me give you an example. Somebody gets arrested, say on an impeding breath, domestic violence case. The bond is set at $10,000. Family, mother or relative calls and says, hey, I want to get, Alfredo Zuniga out of jail. Okay. I look him up. He's got a $10,000 bond. What we do in general, on average, is charge 10%, which is $1,000. We post a bond for $10,000 with the court. That defendant is now my responsibility. My job is to make sure he appears for all his court dates until his case is disposed of, whether it's probation, dismissal, or jail time. If for some reason that defendant says, you know what, I'm not going to court. You know what, I don't want to deal with this court stuff, I'm not going. He takes off. At that point, I have on felonies, I have 9 months. So in 9 months, I have to have him jailed, brought back to court and jailed, or I pay the $10,000 to the county. So I'm on the hook for 100% of the bond. But in the instances that we have a co-signer, like we'll have mom and dad, somebody that's responsible to say, hey, mom, dad, he didn't go to court. So now you owe me this money in full, the $10,000. Now I can either take them to court or I can work it out with them. They can say, hey, look, we don't have the $10,000, but we can give you $5,000 and we can work it off and pay payments with the rest. Okay. That's the situation. That's the worst case scenario. The middle is that we find him and we have him put back in jail, and we may have to pay some court costs because the county charges us interest on that $10,000 every day that the defendant's out on the warrant. Not to mention that we also have to employ bounty hunters. So that comes at a fee. Usually it's the 10%. So the 10% that we charge on the bond is not even profit anymore because we have to pay a bounty hunter to go find them. So that's the whole different dynamics of how a bond works. But if you remember anything, it's basically, I'm going on the hook for somebody that I've never met.
Got
Because
it.
mind you, when they come to sign for him, the defendant's in jail. I've never met him. I only know what I pull up on the screen. I have to look at mom and dad. And again, these are average people. These are not rich people. These are people working class, hey, we want to get him out. And oftentimes they don't even have the whole $1,000 and we still work with them, which is why this whole attack on us for 10%, we believe would actually hurt the public in situations where they want to bond somebody out. Because we oftentimes can take 600 down, bond him out and let them make payments on the rest.
So Mario, talk to us about how that's determined, that percentage.
It's just a standard. It's just an industry standard. We've all.
Is it a state standard? Is it a national standard? Is it?
Actually, our percentages are based on risk. So for instance, if I bail out people who are undocumented, so they're illegal, they're here in this country illegally, they have no permissions, so they could be deported. So on those kind of bonds, I generally charge 50%. So if the bond's 10,000, I would charge 5, because I have to understand that while they're out on that bond, they could get arrested for something else, get taken immigration and be deported. And therefore I would have to pay $10,000 to the court. So they're a little more high risk.
Yeah. So I'm hearing you say that the person, and correct me if I'm wrong, but I'm hearing you say that that risk is based on risk of not coming back to court, not risk of reoffending or the kind of offense that they might be charged with. It's
Right.
about their ability to come back to court. Is that what I'm hearing?
Sure. And also because we can look somebody up and see their prior criminal history. We can also see when they've jumped bond before. So obviously when you see that, you're going to say, hey, you're a lot more of a risk this time around because you didn't go to court on your last.
How does someone find a bonds person? Let's say I'm arrested and I need to make bond. What would I do?
Okay, well, in this county, we're licensed by county, so there's only about 80 of us, which is pretty small when you consider the size of Harris County. But yeah, they would just look us up. They would Google. Generally, if they Google their zip code, it'll bring them to the closest bonding company, and that's generally how most of them start. And then if they don't like the price, then they obviously shop around.
Yeah, that was going to be my next question.
Yeah.
Do people bail shop, bond
Yes.
shop?
Yes, they do. Yeah, they'll throw out and say, well, another bonding company offered to do it for this much. And I'll turn it down and say, well, you know what? That's a pretty good deal. You should probably run with it because I would charge you more.
Yeah.
And I would explain why, because the risk factor. So those kind of things would it's a risk assessment is what it is.
Yeah.
But
I think what I'm hearing, and I think what's important in terms of, we're looking at this through the lens of domestic violence, intimate partner violence cases. And the risk that you're speaking to would be their risk for showing back up for the hearing, not so much the risk of the offense that they are currently charged with. Because in our world, we talk about risk in a much different way from the domestic violence perspective. Does that make sense?
No, and that's a question I can't answer, because what I tend to find with domestic violence is that the perpetrator generally tends to be somebody who doesn't like to follow rules anyway. So they're generally going to have a lot of attitude when they get out. They'll tell you everything from, well, she just lied. The mother comes with him and says, yeah, this girl's crazy and she's just putting these charges on it. But then you start looking at their history and you see that they've assaulted other people in the past.
Yeah.
So they're generally an attitude problem there.
Yeah.
Because they take it out on you. So that factors into my risk as well. Is this somebody that's going to take off and just say, you know what, she lied, and therefore I'm not going to conform to what the criminal justice system wants from me, because I shouldn't even be in this situation.
Yeah.
And that's the accountability factor that can be. Unfortunately, we hear a lot of people say they're innocent. I'm not saying they're not, but given history factors, okay, you've assaulted 2 other people before, so they're all lying. They're all not saying that the truth about you. I don't know. It's not my job, but the risk, and then you often, let me tell you another factor, that you get a lot of women that will come in and want to bond out the offender. So we
Sure.
have to grapple with that. Some
Sure.
bonding companies won't do it. They'll be like, no, you're the victim. But there's nothing that that prevents us from doing that.
Sure.
But it's disheartening to see somebody who says, well, I got to bond him out because he's the breadwinner.
Absolutely.
I got to bond him out because he's threatened me, saying that if I don't get him out, he's going to do worse.
Absolutely.
So these are all things that we're like, I've even turned bonds down and said, next time he might kill you. Hey, you know what? This happened in front of your children. Doesn't that affect you in that your children witnessed mommy being beat up, which they remember that for a long time.
Yeah.
So these are things that I take as a personal responsibility, but I can't speak for every other bondsman. But I would say, hey, look, he's not allowed to go live with you. The protective order that's going to be in place, oftentimes they go back home.
Yeah.
But I tell the defendant, if you go back home and you guys have an argument, you're in violation of that protective order. You shouldn't even be there. Well, or they get them to sign affidavits saying that nothing happened when you know something happened.
Yeah.
So that's disheartening as well. So those all factor into the risk of, do I want to have a guy that goes out and actually murders the victim next time and have that on my conscience? So these are things that I struggle with, to be honest.
Thank you so much for sharing that, Mario. And I think you're speaking to a crowd of folks that are working with the survivor on the other side and have heard the same things, and they're all valid points. I'm wondering, and I'm going to take a little bit of a rabbit trail here, and then I want to get back on course with some other questions, but because I'm wondering if there's not opportunity for some collaborative efforts between domestic violence organizations to provide some education and support to bail bondsmen and companies in the future. So we're going to stick a pin in that and come back to that in a little bit. Okay.
All right.
Can you talk to us a little bit about in terms of your role as a bondsman, who are you, what systems or organizations, or who do you have a duty to maintain contact with and have communication with?
You're talking about from the courts to the defendant to the co-signers?
Yep. All of those.
Right. Okay. Well, the defendant, of course, has to check in weekly. Any bonds over 10,000, they have to report in person and come sign in my office once a week. So the co-signer oftentimes will call and say, hey, is the defendant checking in? Yes, he is. Or no, he missed a check-in. The court, if I decide that the defendant has become too much of a risk or a liability or a problem, I can go to the court and file an affidavit of surrender, which is to remove myself off that bond, and a warrant goes out for the defendant. Now, I have to also notify the criminal defense lawyer in that situation. So the defendant has an opportunity to be aware of what I'm doing. But that also puts me at a greater risk that the defendant may not show up to court either, because I'm tipping my hand that, hey, the bondsman wants to put me back in jail. So maybe I just won't go to court anymore, which gives me the problem of having to locate him now. But I'm okay. That's the law. That's the statute. I have to do it. So I do it. But I oftentimes, look, being that I've been in a situation where some of these defendants are, as far as being in trouble with the criminal justice system, I try to have a talk with them. Hey, look, my goal is not to throw you back in jail. My goal is that you stay out and you earn the freedom that your parents paid for, or whoever paid for your bond, so that you can get through your case. My goal is not to, hey, let me just find any little reason to throw this guy back in jail, or woman. So I do have to sit down. Hey, look, you're missing check-ins here. What's going on? Well, I don't have a car. Okay, then tell me that. Or you know what? I owe you some money and I don't want to have to see you because I don't have the money. Check in anyway. If you got $50, bring your $50. I know you owe me $200 every pay time, but I'll take the 50 and let you slide on the rest. Just try to catch up. Hey, I got to work out of town. I get it. You got to earn a living. Go work out of town. But let me know these things. Don't keep me in the dark. It's like a parent talking to, a kid, a child. Hey, just keep me in the loop with you. I'll work with you. I'm not looking to throw you back in jail, but stay in contact.
Yeah.
So these are the contact procedures and protocols that we go through. But at some point, you got to cut your ties and go, hey, this guy just doesn't care one way or the other what I do.
Yeah.
So there has to be some teeth in what you say, or otherwise it can escalate into a problem.
Thank you. Can you talk to us a little bit about your role on the bail bonds, the Harris County bail bonds board, and what is the role of that board?
The board itself is strictly regulatory. So we regulate the statutes and the laws as they're written or interpreted as to what bondsman can do. Mostly it's a licensing regulatory board. Who qualifies for a license?
So those 80 bonds companies that are in Harris County are all duly accountable to this board. Is that correct?
Yes. Okay. And we come up for renewal every 2 to 3 years.
Okay.
So once you get a license, you're not just left to run a bonding company. You're brought up each 2 to 3 years for relicensing. And the board can ask you any kind of questions like procedure and how you run your company and how well of the knowledge of the bonding company how well of the industry do you know the rules and the laws. But at the end of the day, the basic hurdles are you can't have any felonies to be an owner, and you have to have worked for a bail bonding company at least 1 year within a 2-year period. So, and you have to take a bail bond course before you come up for relicensing. It's an 8-hour course. It's like continuing legal education. And those are basically what you have to do. Now, the Sheriff's Department, because they are an arm of this regulatory board, they can come and view our files at any moment. They can come in and say, I want to see a file on so-and-so. They can see our receipt. They can see our contract. They can see any of that. It's all open. So when people try to make it sound like bondsmen are unscrupulous and we're hiding things, we've always been able to be looked at from the Sheriff's Department, which is, I don't know if you remember, but the sheriff came out at the bail bond board this month and said that he did a review and most of us are charging 8 to 10%. So your 10% issue, if it was imposed, would really solve nothing. Because what are you going to do when people pay the 10% to still get out? Are you going to raise it to 50 or 20? It doesn't solve what they want it to solve. So that's what the board does. It's a regulatory board. We believe that by them imposing 10% onto the local level, they don't have the legal leg to stand on. Because I've done some legal research. We believe that it would have to be changed to the legislative level, which, as you were aware, Senator Whitmire has come out publicly and said it'll be something that he will propose a bill at in the next legislative session, which would be the right avenue if you want to impose 10%.
Thank you for that. I think there's a really great question in the chat that goes back to one of the earlier questions. Can you talk a little more about the process for a victim who's also the co-signer to take herself off of the bond paperwork if it was due to threats out of fear or out of fear for her safety?
And we take that. I take that as a legitimate issue. I say, okay, well, what happened? I mean, I actually hear them out and say, hey, look, we tried to get back together, but he punched holes in the walls. I actually had a client where she was working from home and he got up and he threw bleach on her and burned out her computer, and because he didn't like the way she said good morning to him. So she left the apartment, was calling me, and I said, number one, where is he at? Well, he's back in the apartment laying down. Do not go back, call the police, wait outside the apartment. I instructed her to call the police, and they went in and took him into custody. When he was in custody for the new assault, I went and surrendered his bond on the other charge. So now he's held back in jail on 2 charges. The original one that I got off of, and the new charge. So now he would have to make bond through somebody else and pay for new bonds all over again.
So
Which is
Mario,
what-
you're becoming a domestic violence advocate. And I don't think you even know it.
I mean, I don't want that on my conscience that somebody gets killed.
Yeah.
I don't know how other people do it. And again, I don't know if you guys remember, but I took a lot of heat in front of the commissioner's court when I spoke before them about naming 6 of the bonding companies that that were doing 2 to 3% bonds. I don't know if any of you guys were aware of that. And
Yeah.
I spoke the truth, and some people didn't like it, but you have to understand what the 2 or 3% is, how it's being done. I won't name those companies again because if anybody, the reporters called me like crazy, wanting to know why, name them. And I'm like, no, you've got me on the record. If you want to know those names again, you can certainly check into the commissioner's court and hear it for yourself. But yeah, I feel that I have to balance and make ourselves accountable like any industry, or for instance, police have to be accountable.
Yeah.
Criminal defendants have to be accountable. At the end of the day, think about it like this. We all want the same thing. The victim wants the defendant to go to court and absolve and finish the case, right? Get justice. The bondsman wants him to go to court because we want to secure our money and make sure it's not a forfeiture that we have to pay. The prosecutor wants the defendant to go to court because they want to prosecute and get what they need to get for the victim. The judge wants the same thing, to clear their docket. So if you think about our common ground is that we all want the same thing. We all want the defendant to finish his case, dispose of it.
Right.
So we're really not all that different in that we may have reasons for wanting the same thing, but we want the same thing.
Yeah.
My
Well,
motivation. Go ahead.
And what you really spoke to was addressing safety, right? That and again, I think for us and the reason for us to convene this and to have this deliberate dialogue is increasing avenues and pathways to safety. How do we collectively link arms across systems to, one, so that each system and organization and entity is carrying out its own mission, and we're all increasing safety for our most vulnerable and for our community members, right? That's what this is all about.
Well, isn't recidivism the magic number? Isn't that the main number that we're all trying to bring down? Kim Ogg's own report, 60-page report, said recidivism is 500% right now. 95% reoffense within the first year. Within 6 months, it's 113%. Within 90 days, it's 139% reoffense rates.
Yeah.
So I didn't know those numbers were that big, but I knew that there was a pattern of reoffense that was happening after the O'Donnell settlement. They were coming back faster. When clients would call my office and have me look somebody up, I'm going, this guy just got out on a PR bond 3 weeks ago. And you mean to tell me they're back with a new charge?
Yeah.
Which is why the backlog is happening. 150,000 criminal cases when we only had 30,000 in 2019.
Right.
So if you can see how massive it's grown. Look, I'm all for, wanting to curb, especially when it comes to domestic violence. Why are men or women what can we do to make them less violent? Anger management. What is it that triggers you? Why do you get mad? What's that deeper root? I want to understand that. Hey, I was a young man once and I had girlfriends, and God knows there was a time when, I wanted to take a slap or a punch, but I had to go outside and smoke a cigarette or walk around the block. And I would always come back with man, I'm sure glad I didn't hit anybody. I might have said some mean things, but I was always glad that I didn't put my hands on people, and I think that that's what I try to tell guys, like, hey, look, I get it. Women can drive us crazy sometimes, but wouldn't you be better off if you just went outside and walked around the block and calmed down and put it in perspective that it really is not that bad what was happening? Give yourself some time before you explode. That's why PR bonds are so bad, because there's no cooling off period like there used to be.
Yeah.
They're out in 24 hours. There used to be a cooling off period. They used to set a no bail or a $50,000 bail, and then they would go to, it was a misdemeanor, $50,000. Most defendants were processed from the little jail back to the county. You'd tack on about 14 hours, 15 hours, 20 hours, and then they calm down. And then they're out and they're not so mad.
Yeah, well, I think, I mean, that we could have a whole 8-hour discussion about a cooling off period in domestic violence, because I think that looks very different. You know, in domestic violence, we're talking about coercive control. We're not talking about a one-time incident. It's a pattern and a backstory and a history of lots of types of control that are used. So often that cooling off period doesn't really apply in a domestic violence case. I want to go.
I mean that more like with first time.
Yeah, it's okay. I think.
Yeah, when you see a pattern, you already know that that's beyond cooling off. That's psychological. That's verbal. It's like a form of brainwashing.
Well, and what you were addressing is how do we find ways to offer interventions for those that are using harm in their intimate relationships so that they're no longer using harm, right? That's the key. That's prevention. That's preventing it from happening again to the same person or to a future partner, right? That's where we have to start spending a lot of energy and time thinking about what those interventions are. And that is, in the future, you're going to hear some of the work that the coordinating council is doing in that area. I want to go back. There's another question in the chat that I want to go back to. Amy's asking, you talked about that you have weekly check-ins with the person who's on bond. Is that the standard? Is that the norm, or is that your practice?
Most bondsmen have a call-in. On smaller bonds and less serious offenses, most bonding companies will have some sort of check-in protocol. They all do, because we all want to know where they're at. When phone numbers get changed, we want to know their new number. Sometimes they'll call you from a different number and you log those numbers. If they got different phones, or they're so unfortunately we deal with people that constantly get their phones cut off and get new numbers. Yeah. So we deal with that. So the calling in is a pretty standard deal. Now, when they want somebody to check in person, that varies from bonding company to bonding company. Yeah. But we do all have a call-in protocol.
Thank you. Do other bonding companies also surrender the bond on the original case if the defendant picks up a new violent charge?
Not always. Sometimes what they'll wait to see is if the defendant's going to get a bond on the other charge, and then decide if they want to bond him on that new charge. Okay. And that's assuming the judge doesn't revoke the other bond and raise it, or something, that those dynamics that play out. But if the defendant was a bad defendant while he was on the first bond, then the bondsman tends to go, you know what, you're not a good risk, because now the risk is going up. You are already irresponsible on a $10,000 bond. Now I'm going to go on the hook for a 50 plus the 10, and you weren't even following the rules at a 10. So that's another part of the risk assessment that goes through our mind at that moment. Got it.
Mario, do you have any idea, or do you know, I mean, you probably know from your own company, but I'm wondering from the broader picture of what percentage of your business are intimate partner domestic violence bonds?
They used to be a lot before bail reform. Bail reform started treating that as a non-violent. So we saw less and less of those.
So that's what you're seeing less of those now? Is that what you're saying?
We're bonding less of amount. I'm not saying that less of them are happening. I'm saying that we're seeing less. If we do get a bond, it's usually when they violated protective order. And the judge, and sometimes it's multiple times. When you start to go through the record of the courts, you find out they violated the protective order many times, and the judge never violated the protective order until the 6th time. So we're seeing that as more of we're giving you more chances, but we're bonding less of them, but domestic violence is still happening. Of course, in the pandemic, you saw an increase, but that didn't mean we were bonding them. That just meant that the court was giving them more of a way to bond out without paying a bondsman.
Okay. Can you speak, can you go back to that, the protective order violations again and talk more about that? You said, I heard you say 6 times.
Yeah,
How do we find that data? Where does that data, how would we find, if we were looking for that data, how would we find it?
you could go into the, well, like for instance, when pretrial is monitoring them, there's a report with pretrial services. There's also when the judge decides to revoke or violate, when the judge decides to revoke the, when you go to the district clerk and the images, that's generally where you'll find those documents. And generally there's a list of reasons as to why. Revoking the bond. Because, you know, oftentimes the victim will call and say, hey, you know, he's back over here. He's sending me threatening text messages. He showed up at my job. They've already called the DA. They've already made these calls and they're getting no feedback. So now they're in a state of, what do I do? At that point, and mind you, a judge can refuse to sign my surrender. I can go up there with it and have all these reasons listed. And the judge can say, well, I'm not going to sign it. I'm going to deny your surrender.
Yeah.
So I can jump through the hoops and do my part, but it's not a guarantee that a judge will side with me. But yeah, that's, and my surrender is imaged in with the documents. So if you ever see a bond surrender, you'll see the bondsman listing his reasons.
Got it.
So that's a part of the public record as well.
Thank you. Before I take the pen out of the question that I stuck in the parking lot earlier, I want to make sure that those of you that are listening, please drop any questions that you have in the chat. We're going to start winding up in the next few minutes. But Mario, can you spend a little time thinking about, and again, through the lens of domestic violence, intimate partner violence, what else, if you could make recommendations or change for your role as a bail bonds person in that realm, what would that look like?
Well, I think the protective order should be taken more seriously. I think they should have more teeth. I think that should be taken that's the number one thing that is your defense mechanism. I get it. It's on paper and it's not going to save you, but you know, if somebody's that crazy and violent, not a whole lot that's going to happen there, but that's the first start. And to require that the judge, you know, sternly, hey, you know, if I find out you're over there. So number one, the protective orders, swift revocation of the bond. I think that I know it's pre-trial. I know that they're not convicted of anything, which is what's being said, but pretrial services in its current form is actually having them pay money and check in with a probation officer as if they are being already found guilty of something. So I think if that's what pretrial services is going to do, I think they could actually maybe even add some type of domestic violence course. I mean, if you're already doing these things to them, then why not just say, hey, look, you know what? Maybe you're not guilty of this, but this can't hurt to sit there and learn about what the triggers are and maybe see the psychology of what you're doing to your mate. You know, when you tell them things like nobody's ever going to want you, you're not good enough. You know, every man, they may not admit to it in that room, but that light bulb is going to go on and go, yeah, I do say those things. Because ultimately they're going to be like, I don't belong in this room. I'm not an abuser.
Yeah.
But then the light bulb's going to go off and go, yeah, I do say that to her.
Yeah.
I do tear down her self-esteem. I do tell her she looks ugly in what she's wearing. I do those things and that's me. There you go. Now we're on the way to trying to get you to understand what you were doing wrong.
Yeah.
I mean, you can't save them all, but maybe that's a good start to say, well, hey, if you're gonna have to report to pretrial, let's put you on the road to this right now. Maybe you'll learn something while you're on this. So those are two things that I think, I don't know. I mean, it's domestic violence and with intimate partners it's complicated.
It is. Human beings are complicated. Absolutely. And I think when we're in a setting as large as Harris County, this urban county, it's, it would be easy if we had a cookie cutter checklist and everybody fit in, but we don't, right? And that's the complexity here, that we're talking about human beings and we're talking about lives. And
What now that when you just said that and I'm thinking about it and I'm thinking, well, here's an idea. Hey, why not just make it like marriage counseling? I mean, bring both partners in,
Yeah.
bring them both in, let them sit there and let them hash it out and say, hey, you know what? I don't like the way you talk to me. Or even a therapist can read when a woman's, scared to speak up. I've had defendants walk in with the girl and say, you need to hurry up with that paperwork, or just put this down, like controlling them. And I've had to send the guy outside and go, you're not going to do that here. Then I have to rethink that and go, how do I know she's not getting beat up at home because I took up for her? So
exactly.
it's a complicated
It is
situation.
yes, it is.
And I've had to learn to, well, how do I, but I think that would be a good start. The violation of protective orders carrying more weight and giving them some kind of avenue to want to understand their own behavior as a domestic violence abuser.
Thank you for that, Mario. There's a couple more questions that have come up in the chat. One is, Jose says, is there a rule that the defendant is required to live at the address that was listed on the bond?
No. No, sometimes their situation changes and they just notifies that they're moving. We don't list their address on the bond itself. The defendant does when he signs the bond, when he's in jail, but we're not there for that process. But generally we get where they're living from mom and dad or whoever's coming to bond him out. Where is he going to be living when he gets out? Well, he's going to be living with me. Okay, what's your address? Well, it's the same as what I put on my application. Now, if that changes, then we adjust, but there's no rule. No.
Okay.
We just want to be aware where you're at.
Got it. Is there a bond when a person is in a pretrial diversion program?
Pretrial diversion is usually like where they reset the case off for a year, which it's a form of probation, but it's not like deferred. What this basically does is reset your case off for a year. You jump through the hoops of what they want you to do, probation, classes, and at the end of that year, you go back to court and they dismiss your case. So pretrial diversion is a way for people to get a dismissal that shows up on their record as my case was dismissed. And then, of course, as the statute runs out, you can go back and have that expunged. 2 years on misdemeanors and 5 years on felonies.
Okay.
So those are usually meant for first-time offenders. But yes, they would be on a bond that whole year.
Thank you for that. When a defendant lists their address, do you ever compare it to see if it's the same as the victim's address?
Um,
Does that come into play at all ever? And if not, is there opportunity to explore that a little bit?
well, generally the protective orders are online.
Yeah.
So if I want to compare that, I can just print it and say, hey, look, this is where they said you're not supposed to be going, and this is the address you listed. So
do you I'm hearing you, that's something that you do. Do other bondsmen do that? Is it up to personal choice? So if someone is on bond, you may or may not know that there's a protective order in place, correct? Unless you go look for it.
By and large, by procedure, a protective order is 99% of the time there. It's there. The question is I don't, to be honest with you, I don't go looking for it and comparing those kind of things until there's a situation where the victim calls and says, hey, this guy's bothering me. Generally, your victims are a great source of, they're going to tell you the truth. We got back together. We know we weren't supposed to. He wasn't supposed to be living here, but we got back together because he wanted to see the kids, and then he started going crazy again. And, okay, so how long has he been there with you? Well, he was living here 2 months. Okay, so he obviously violated the protective order. But a lot of those things, no, we don't know right out front unless we go digging into each time a bond is made on a domestic violence case.
Got it. Thank you for that. I think, Nikkei, I'm going to take the pin out because I think you're making a great point. And, you know, earlier, Mario, we talked about there might be an opportunity for some collaborative efforts for some education for bail bonds companies related to intimate partner violence. And so that's my question to you. Is that something that, you know, you think folks might be open to? And if so, would you be willing to assist in making those connections?
Let me be clear. I've always been, the problem is that when bail reform came, they didn't want our input, which we could have showed them a lot of the pitfalls.
Yeah.
We could have showed them about ankle monitors and pretrial services. And I told news reporters, they go, well, what's wrong with pretrial service? I said, the information isn't being vetted. Number one, what you just said about comparing addresses. So if a defendant puts to answer your question quickly, is to say that our insight, if you remove the idea that we make money off of bail, and to understand how we don't have a crystal ball.
Right.
We only have access to limited information, criminal histories.
Yeah.
And we're making these decisions, but our failure to appear rate is only 10%.
Yeah.
Under the current bail reform system, it's over 50%. So if you look at that through those eyes, you're going, okay, what is it that the bondsman, we could learn from them? I'm not saying you have to take everything we propose, but at least hear it out.
Yeah.
And contemplate it for a little bit and see if it makes sense to you.
Right.
Because most of it does. It's just basic cookie cutter, vet, make sure they're telling you the truth, check them in, keep them honest. That's all.
Yeah.
No, I absolutely would be more than happy and put aside any differences and any angry rhetoric that people have said about us or me and say, hey, you know what? Let's clean the slate. Let's start over and let's get back to making the city safe again.
Fantastic. Well, and what might be a really good starting point is, you know, I could foresee in the future maybe us hosting a lunch and learn where we invite bail bonds companies to come tell us what you've learned in all of your years of intervening and working in these cases and set, you know, bonding folks out when there's domestic violence. Tell us what you know, us listening, and then us offering information back. Like it's more of a discussion and not, you know, let us tell you what it is, but we have this really rich open dialogue with one another about what's happening. So I see that as a follow-up for you, and we will be reaching out to you and see if that's something that we might be able to coordinate, and we can certainly invite folks to come be a part of that. So thank you for that.
Welcome. Any opportunity, I would greatly appreciate it. And if you can put that together, I would more than happy like to be there. And I'm an open book as well. I mean, I'm there to learn too. I mean, I'm sure there are things that I haven't thought about that the other side could tell me.
Yep.
Yeah, we're not going to be preaching to each other. We're just,
yeah,
I want women and people to be safe.
Absolutely. Absolutely. And that shows, and that's come across as you've shared with us so openly and honestly and transparently tonight, Mario. I thank you for that so much. I don't see any other questions in the chat. I think I have to say thank you that we had you all to ourselves tonight, because we really were able to dig in and really get some great information.
Can I finish with something really quick?
Yeah,
If
please.
you remember anything about me, remember this. If I lose money because I'm doing less domestic violence cases because people are learning and reforming, I'll more than happy deal with that. I'll live with it. Even if I got to find something else to do, I'll deal with it, and I'll greatly accept that that's reform. So don't, please, people box us bondsmen into money hungry, greedy. And again, there's 80 of us, and I only represent us as an association, but I want to be clear that I've been on so many different sides of the criminal justice system that I have a unique perspective that other bondsmen don't have,
Yeah.
because I've been in those walls before myself.
Yeah. Well, thank you for that, Mario. And it takes all of us working together.
So,
We at the coordinating council have a quote that we stick up everywhere we can from Helen Keller. She said, alone we can do so little, but together we can do so much. And you taking the time to be with us tonight and offer us information and share openly and honestly is just so valuable. And we thank you so very much.
welcome. Thank you for having me. Absolutely.
Yeah. And to those of you in the audience, thank you so much for taking time out of your evening to be here with us. I think there's going to be a survey that gets distributed. I'm not sure how that's going to happen. Does somebody, I think,
It's in the chat box now. So if you'll just click on that to provide us feedback that will help us to continue to have more deliberate dialogues. And again, just making sure that you found value in tonight.
fantastic. Amy, do you want to close us up and talk about our next offering?
Sure. And Mario, I think you're going to be stuck with us forever. So thank you. That was fabulous. And we really, really appreciate your time. And you are an amazing human, and you're an amazing bond person. So yeah, so thank you for that. Also, so next month on April the 28th, April the 28th, our topic will be post-conviction. So post-conviction, we'll be looking at probation and parole, or community supervision and corrections, whatever their title is, but there will always be probation to me. But
I've been on probation before.
so
Yeah.
it'll be our speakers will be Mona Pena, who is the Region 3 Director for the parole, and and Trina Willis, who is the Assistant Director at the Probation Department, or Community Corrections and Supervision Department. Anyway, we hope you can join us then. It'll be same time, same bat time, same bat channel.
To give you guys also to let you know that the next Harris County Bail Bond Board meeting is on the 13th, and we think that they're going to put on the agenda the 10%. So we think it's going to come up again, and I'm preparing for that. So if anybody wants to go to speak on the issue of domestic violence, that would be your chance to speak.
Thank you for that, Mario. That's good to know.
It's 1:30 p.m. It's the second Wednesday of every month, so that would be the 13th of April at 1:30 p.m. at the where Commissioner's Court is held. Preston, 1001 Preston.
Yes.
So if you guys want to speak about domestic violence and the impact of it as it pertains to 10%, you guys are more than welcome to show up.
Thank you. It's on the 9th floor.
Yeah, 9th floor.
Right.
That is a great tidbit of information. All right.
Thank you so much.
Yeah. Thank you, everyone.
Thank
Have
you.
a lovely evening. My dog is barking to go outside.
Good night.
All right. Good night, everyone.
Thank you so much.